Good afternoon and welcome to today's post-cabinet press conference. Today I'm joined by three of my colleagues, Attorney General, the Honorable Faris Al-Rawi, Minister of Education, the Honorable Anthony Garcia, and the Minister of National Security, the Honorable Edmund Dillon. Now, what we're going to do today is that each minister will make the announcements respective to their portfolios, and then we'll entertain your questions. So we start with the Honorable Attorney General.
Thank you, Minister. Ladies and gentlemen, I'm here to report on a few matters. Firstly, to deal with issues of legislation, which the Cabinet has already approved, one which we have just approved, and then also to speak to the issue of the cane farming rights that are being advocated right now, and also to receive your general comments. I'm very pleased to inform that the Cabinet took a decision today in approving a recommendation of the Law Reform Commission, the Legislative Review Commission. Cabinet took the decision today to support legislation which is proposing to amend the SSA legislation, specifically to broaden the mandate of the SSA in allowing it to surveil what is now going to be referred to as serious crimes. This is a very multidimensional tool which is intended to harmonize all of the state assets which the various aspects of Ministry of National Security and Office of the Prime Minister have control of. For instance, the National Operations Center, the disparate pieces of equipment which were left lying around in the Ministry of National Security, be they helicopters, etc., and to centralize them so that the legislation can manage all intelligence-led obligations which Trinidad and Tobago has to deal with its international obligations, firstly, be they in precursor chemicals or psychotropic substances or small arms, weapons of mass destruction, terrorism and the fight against terrorism, national issues to deal with money laundering, etc. It is critical that there is a harmonization and a one focal point created to deal with these issues across the table. Secondly, of course, it is to ensure that the phenomenon of the siloing of information, which has led to a significant amount of inefficiency in detection and conviction, is taken care of. So it is a specific approach to de-silo the management of intelligent-led investigation. This is intended as a tool to support and only support the activities of what is referred to as the services. And the services are defined by law as the Trinidad and Tobago Police Service, the Customs, Immigration, etc. It is important, and the government has done a significant amount of work, both from an operationalization point of view and from a legislative point of view, over the last 6 months, and we are now properly teed up and ready to progress with the harmonization effort so that there can be a material improvement in detection and conviction. Crime and the management and suppression of crime, the move to eradicate this scourge from the society is the #1 issue affecting us in Trinidad and Tobago. And it's high time that the people of Trinidad and Tobago saw and see the benefit of a coordinated approach towards dealing with crime, getting rid of this scourge. The second matter, which is a matter which I will share with the Minister of National Security in terms of his response, will be the progress on Friday, as is intended in Parliament, of debating and launching the Children and Family Bill. That is a new division of the Supreme Court of Judicature, intended specifically to bring to life the specialist areas to manage youth offenders, children who are charged with crimes, that is both convicted and charged issues, and also to deal with family matters. It springboards from the Family Court Pilot Project, and very specifically, it is intended to have a very dedicated subset of the judiciary with full powers merging the magistracy and the High Court jurisdictions so that there can be one suite of services to work and operationalize the children's laws. And by children's laws, I'm referring to the suite of legislation which Trinidad and Tobago has, which includes a number of pieces of law, such as the Children's Act 2012, the Children and Foster Care Nurseries, the Children's Homes, etc. All of these disparate pieces, including in particular how youth offenders are managed. And the position is one intended to ensure that there is adequate protection for the children of Trinidad and Tobago, and it is intended to be a material fillip and improvement to the operations of the Children's Authority and the judicial process. The Minister of National Security will speak to a very important decision of the Cabinet taken today relative to the Trinidad and Tobago Police Services improvement of the arrangements to coordinate with that, and I will leave that for the Honourable Minister. There's a third issue that I wish to address this morning, and that has to deal with the claims brought forward on behalf of persons who were previously involved in sugarcane industry. The position out in the public domain at present is that there has been an allegation, a very vociferous allegation, ending in a public demonstration yesterday, that this government is somehow not acting with dispatch in relation to the claims for the payment of monies which come out of the European Union's grant funding to the government of Trinidad and Tobago. I wish to put onto the record that it is a matter of long history that the sugarcane industry has been attended to by successive governments. The Cotonou Agreement, which provided welfare and protection of market for the Trinidad and Tobago cane industry, was signed, and its ending was organized by the United National Congress under the Prime Ministership of then Bastio Panday. That's where the unwinding of the Caroni situation began, Caroni being synonymous with sugarcane, as is being represented in the current dynamic. Following upon that, Trinidad and Tobago is well aware that there was an ending of the sugarcane industry, and that part of the very attractive VSEP packages offered to the persons who were involved in the sugarcane industry involved not only the disposition of lands, not only the support of wages, not only the write-off of debt, not only the write-off of taxation, but there was specifically negotiated by the PNM administration a material support offered by the European Union for the retooling and re-education efforts for persons who are now displaced out of an industry. That, ladies and gentlemen, has sat in the landscape of Trinidad and Tobago's legal history in a state of idleness in the period 2010 to 2015. And I wish to put onto the public record that the government of Trinidad and Tobago on the 26th of September 2011 received specific written advice from the then Attorney General, Mr. Anand Ram Logan, at the request of persons including the last Prime Minister and the Minister of Planning in the last government. And that specific advice was in relation to the Sugar Diversification Program, and that is the European Union funded program. That's the monies that are now being asked to be paid across to cane farmers, ex-cane farmers. And the written opinion of the Attorney General, ladies and gentlemen, Mr. Anand Ram Logan, some 18 pages long, specifically said that there was no merit in the payment. That is the written opinion of Anand Ram Logan to his Prime Minister, Kamla Persad Bissessar. The written opinion is the very written opinion that the Honorable Prime Minister, Dr. Rowley, referred to when asked by Mrs. Persad Bissessar in the Parliament about this issue. Now, it is a matter of record that during the August 2015 election campaign, that Dr. Rowley, in speaking at a public meeting, publicly announced that there was, in essence, a continuation of government and governance, and that obligations which were to be honored would be honored. Mrs. Persad Bissessar, as leader of the opposition, asked of Dr. Rowley a specific question in Parliament. And on the 20th of January 2016, she posed the question to Dr. Rowley. And Dr. Rowley's advice was, the legal advice was that it was not in order to make that payment. The government went ahead and made that payment against the advice of the Attorney General, and for election purposes offered to make a payment, paid half, and are now asking me to pay when I'll pay the other half. That is what Dr. Rowley said in Parliament. And the advice that he was referring to was and is the written advice of Anand Ram Logan, which condemned the payment. So when one sees today on the streets ministers of the past government walking with persons who are in distress, ex-employees of the sugarcane industry, speaking as if the written advice is the advice of the present Attorney General or the present government, one has to be very careful to pick sense from nonsense. The fact is, this matter was brought with dispatch to the current cabinet of Trinidad and Tobago. The Minister of Planning was requested to produce advice in relation to the matter for the payment of these monies. The Office of the Attorney General has been requested to produce advice, and the Minister of Agriculture was also requested to give input. The reason that that process was adopted is quite simple. There being written opinion of the past Attorney General specifically preventing the payment of these monies, it is incumbent, obviously, to take the proper steps to make sure that the current government's policy to pay the monies can be approved in the proper line that it has to be approved. And I'm very pleased to say that this matter is achieving the attention of the cabinet at present. There's only one bit of advice outstanding, and I will publicly state today that I will be requesting, as a matter of propriety, from the European Union confirmation of its position in relation to the proposed payments as are now being agitated. Because it is probably worthwhile, specifically in light of Anand Ram Logan's written 18-page opinion saying that it cannot be paid, it is worth the while to make sure that the person who has provided, or the entity that has provided the funding, gives its non-objection or neutral position in relation to the policy input that the present government will have to approve in the cabinet decision. Ladies and gentlemen, this is done only for propriety and solely to ensure that the effort of funding via the European Union in future or related transactions will not be prejudiced by the adoption of an improper process. It is unfortunate in the extreme that those who now sit in opposition, who sat on this matter for as many years as they have, now choose to march across Trinidad and Tobago and essentially, from my own point of view, seek to exploit the difficulties of persons who are agitating for a particular right. The proper process is that the I's have to be dotted and the T's have to be crossed, and that we will, in fact, be traversing this matter with care and caution, but with expedition. I will pass, after this conference, a full copy of the written opinion by Anand Ram Logan, dated, as I've referred you to, the 26th of September 2011, and that I will make this available for public consumption. But the short undertaking is that this matter is being dealt with, and being dealt with proper alacrity. The last issue to clarify in relation to this is that it is regrettable that there has been a promotion of what seems to be a cleave in our society. I wish to publicly condemn the machinations, the maneuvers that are afoot by certain people on the outside in opposition, and I'm not referring to anyone in the media by any stroke of the imagination, to try and cleave this thing along societal lines of division. This is inappropriate. This is a matter of just dotting I's and crossing T's, and certainly that this present government will make sure that legitimate expectations and proper legal obligations are mapped out in the proper way, and that decisions are then fueled and funneled in that direction. I will wait until the end of the news conference to address the specific questions that come from the media corps, so that I may allow my colleague ministers to speak to the other matters that they may have, and perhaps we'll take the entire event of questioning as a whole. Thank you.
Thank you, AG. Minister Carmen Imber, the Finance Minister, is also here, so I'll allow him to address a few matters.
Good afternoon, everyone. Actually, I have just come very briefly to give some clarification with respect to the funding for this issue, this contentious issue, with respect to the payments to cane farmers from funding from the European Union. I saw a report in the newspapers today, and I have no reason to believe that it's not accurate, the report, that former Minister Tiwari, now MP for Caroni East, Caroni East, Central, said that the money allocated to pay cane farmers was received in October of 2015, and therefore there should be no difficulty with the government paying the money. So what he essentially said is that the European Union had agreed to provide this funding to pay cane farmers, and that the money had been received, a second tranche of $75 million had been received in October 2015. This is in today's Express on page 3, at the bottom. I've checked, and that information is not true. The second tranche of funds was not received. And the reason why it was not received is that there were certain conditionalities that had to be met in order for that second tranche to be disbursed. And I can just give you an idea of what they were. The former government had been told that they would have to meet certain indicators comprising 2,000 acres of former Caroni lands under agricultural production, plan formulated for integrated water management, and local agricultural production would have to increase by 10%. Those were the conditionalities that the European Union had imposed on the second tranche of funds. And my understanding is that they didn't do what they were supposed to do, so the money was not disbursed by the European Union. So I just, as my colleague to the right is telling me, as they should very well know, so that what Dr. Tiwari has said is just not true. So I simply came to the press conference just to clarify that. I may be able to answer one or two questions, but I'm afraid this is an impromptu appearance by me. So I beg your pardon if I could be able to leave in a couple of minutes. If there's anything else, I'll answer it, but I really have to go after a meeting with some IMF officials.
Thank you, Minister Imber. Before that, we have two other ministers to make their statement.
Okay.
We have two other ministers to make their statement. Minister Garcia.
Thank you very much. Good day, members of the media. Today, Cabinet has taken a decision to establish a task force to review the GATE program, GATE, Government Assistance for Tertiary Education. I just want to give you a brief history of GATE. GATE was introduced in 2004, and since then, 194,000 students have been funded through this program. This program is being offered among 65 institutions, and over the last 11 years, the government has expended the sum of $5.58 billion to fund this program. For fiscal 2016, the sum allocated was $650 million. There have been growing concerns in many areas. One is whether the GATE program is contributing towards economic development. There is a lack of comprehensive data with respect to the graduation rates, the graduation employment figures, market demands, and student migration. There's also the lack of monitoring and tracking of students who were funded by GATE. And because of these concerns, Cabinet today decided on the establishment of this task force. This task force has to submit its report by July this year, July 2016. Some of the work that this task force must be engaged in would be as follows: to review the policy guidelines that govern GATE, to review mechanisms for reducing the overall cost of GATE funding, and to set criteria for the eligibility of programs and also the eligibility of institutions. Members of the task force are as follows: Mr. Errol Sims, Chairman, he's a management consultant. Ms. Teresa Davidson, she's the Director of Funding and Grants at the Ministry of Education. Ms. Nivelle Niles, she's an Education Research Specialist. Dr. Gaynell Holdip from the Ministry of Education, she belongs to the Scholarship and Advanced Training Division. Two representatives from the Ministry of Finance, a representative from the Ministry of Planning and Development, a representative from the Ministry of Labor and Small Enterprise, a representative from the Tobago House of Assembly, Dr. Ralph Balgobin, representing the Trinidad and Tobago Manufacturers Association, Ms. Natasha Subero, representing the Trinidad and Tobago Chamber of Industry and Commerce, Mr. Richard Saunders, the campus registrar at the University of the West Indies St. Augustine campus, Dr. Ruby Allen from the University of Trinidad and Tobago, she's in the area of quality assurance, and Dr. Hyacinth Guy, representing the Human Resource Association of Trinidad and Tobago, Ms. Folande Mutato, representing the Women's Institute for Alternative Development, and the president of the Guild of Undergraduates at St. Augustine campus at the University of the West Indies. So these are members of the task force who have been appointed, and we are hoping that their report would be submitted to the Ministry of Education no later than July this year. I also like to inform the media that next Tuesday, the recipients of the President's Award will receive their medals at a ceremony to be held at the South Campus, SAPA, and the awards will be given to the President's Medal Gold for Higher Education to two most outstanding students as a result of the CAPE examinations that were held in 2015. The President's Medal Silver for students who have excelled in the area of the CSEC examination, and the two students who have excelled in the essay examinations. And as I indicated, this ceremony will be held at SAPA on Tuesday next week, Tuesday the 15th of March. Thank you.
Thank you, Minister Garcia. We just indulge Minister Imbert, who has to leave, so we take one or two questions for him before he departs.
Actually, we are accommodating the media, but the Attorney General just has an update on the same matter I raised about the criteria and the indicators that the country was required to achieve before the EU funds could be disbursed.
Thank you, ladies and gentlemen. You heard the Minister of Finance indicate that the monies have not been released because indicators have to be complied with. I've just received confirmation from the EU, and it is literally in support of what the Minister has said. It specifically is the position that the payment to be released is for budget support. It is a budget support program with funds going directly to the Treasury. Releases, tranches for releases are against achievements of indicators. The activities that are carried out with the funds is not for the EU to vet as long as the objectives and indicators set out in the agreement are achieved. So you have it from confirmation from the Ministry of Finance that the last government had indicators to be achieved pursuant to written agreement, that those indicators were not achieved as they would well know. And you have confirmation from the EU itself saying that tranches are to be released when indicators have been met. So I just wanted to put onto the record that this position is not a unilateral position of the Minister of Finance now sitting, but it is one that has been confirmed also by the EU. We will invite questions on to Mr. Imbert.
Right.
Mr. Minister, what happens at this point in terms of those indicators that both you and the Attorney General are speaking of?
Well, those are really indicators from the Ministry of Agriculture. Let me just recap what they are. 2,000 acres of Caroni lands under cultivation, an integrated water management plan, and a 10% increase in agricultural production. The previous government was supposed to achieve all of that before they could get the tranche of funds from the European Union. They did not, or they have not proven it, because it's not just that you say that you've done it. It has to be validated and verified by the European Union. That process was not done, so the funds were not released. Simple as that.
Is there a target deadline now for the achievement of those indicators?
We are still investigating it. This is all new, because you remember yesterday Dr. Tiwari said the money has been released and is sitting in some bank account somewhere. So I was tasked to determine whether that was true or not, and I've established that is not true. So having established that it's not true, I have now discovered that the money will not be released unless these indicators, which were agreed to by the last government, are met. So obviously now, as a government, we'll have to look at these indicators and see what the actual state of play is, whether they can be met, whether they have been met, how long it would take to meet them, what is required to be done to increase agricultural production by 10%, and so on, and so on, and so on. Okay?
If I could just interrupt to supplement this position. That's only stage one. It may very well be, which is why the Ministry of the Attorney General is involved, that the transaction itself could have moved, and therefore one has to look at the full legal transaction, not only how it has been written, but how it has been performed. And therefore, that's the caution, I's dotted, T's crossed, to try to make sure that the position is clarified. It's quite spectacular that Gerald Ramdeen, attorney at law, well known to many of us for his work for the last government, delivered a letter to the Honorable Prime Minister, copied to me yesterday, advocating rights on behalf of persons who he complained were victims of some form of sabotage, and that none of what we have just told you is included in that letter. So there is a muddling of facts. The position needs to be clarified, because what we don't want to prejudice certainly are the people who are involved and the victims of, the manner in which this has been treated in the last 5 years, certainly. But also, too, one has to be very careful as a government not to prejudice your source of funding or pollution of agreements. If there is to be some form of renegotiation or refactoring to bring what has transpired in fact in line with agreements as performed and not only as written, that needs to be attended to as well. So this precipitation of activity catalyzed by persons in the last government marching the streets yesterday is really quite irresponsible, because they are only speaking half of the position, and they ought to know, because they were in conduct of this themselves. And this is the thing that has to be frowned upon, because what it does is to seek to take advantage of the most vulnerable people in our society by manipulating the perceptions around things which certainly Dr. Tiwari must know, certainly Gerald Ramdeen must know, and there being written advice from Anand Ram Logan, which is the exact opposite of what we're now being told by the last government, now opposition. So we've got to treat these things with great care and caution.
Thank you, AG.
This is for who? Because, oh gosh, he's trying to run away.
Is it that none of the indicators were met, or is it that some of them were met?
That's exactly the same question I asked, because I only got this information a couple of minutes ago, because you'll realize that prior to this, the UNC has been definitely silent on the fact that indicators had to be met. We have no idea. If they had told us that indicators were required to be met and they had to submit a report to the EU, which the EU would then investigate and determine, because you can say that I increase agricultural production by 15%. It may not be true. And the EU is a serious organization, so they would send people to check and see if that is true. So if they had told us that they were required to do these things and then have these things determined, you know, by third-party investigation, and only after that can the funds be released, then they have a completely different complexion on all of this. This is news to me, and I'm sure news to the government, that all of these indicators had to be met before the funds could be dispersed. So now I've discovered this, I will consult with my colleague in the Ministry of Agriculture and find out whether, in fact, these things have been met. If I have to venture a guess, I doubt that the paperwork has been done, because I was told that the necessary reporting wasn't done or wasn't done properly. And this is one of the reasons why the funds were not released.
And the other thing, what is at issue? Is it that the government can receive this money but not pay it out to the farmers? Because it seems to me unusual for the Attorney General to give an opinion that this payment shouldn't be made. So is it that he was saying that the government couldn't get the payment from the EU? Or is it that once the EU gave the government the payment, the government had the authority to keep it for other uses and not pay it out?
Let me just give a preliminary explanation on that, and then I'll leave my colleague to get into the details. When the EU agreed to provide this money, it was for budgetary support. So what the EU would be looking at is all of the money spent by the government with respect to the Caroni situation. And this, at last count, has to be about $11 billion in terms of EMBD, in terms of providing 2-acre parcels to former Caroni workers, in terms of other benefits that they receive. So what the EU was doing, because it was the closure of the sugar industry, they were providing support, budgetary support. This money is just a fraction of the money spent by governments over the last 15 years or so with respect to this matter. So that the EU had said, fine, we recognize you're spending a lot of money, and we provide this as budgetary support. So this was just supposed to go into the consolidated fund to assist in the payment of that $10 or $11 billion. And it was not supposed to be going to any particular individuals. That was the situation before. But the last government apparently sought to change that. And instead of it being budgetary support to supplement the $10 or $12 billion that has been spent, it was, they wanted to get the money going directly to the farmers. And what the EU said is, look, this money is for Trinidad and Tobago, but you have to meet certain indicators first. And once you meet those indicators, then the funds will be released. And this is where the AG now has to look at the legal ramifications of this whole thing.
Thank you.
You see, just to put it in context, the last Prime Minister, Kamla Prasad Bisesa, sat in meetings with the representatives of these entities. The Attorney General, Anand Ram Logan, and several other parties were asked to give advice, and Ram Logan's advice was specifically, you can't do it. We'll pass that advice out. What happened next was a series of actions where the paperwork and inputs didn't keep pace with the flip-flopping that went on by the last government. We are the present government, and therefore it falls upon us. It is our task to clarify the position and to draw the lines together. And let me tell you why. The EU is a significant supporter of significant activities in Trinidad and Tobago, one of which, upcoming, includes support for the CFATF, the Caribbean Financial Action Task Force, and certain work that is to be done in relation to anti-money laundering, which is a big priority item for Trinidad and Tobago under this government. And that being the case, it is incumbent upon a government to make sure that it takes the right steps, that it brings the transition of activities into line, and that there's a proper vouching of positions. We are intent upon doing the right thing. The Prime Minister has stated in no uncertain terms that commitments that are lawful commitments and obligations to the people of Trinidad and Tobago will be met. He has been entirely consistent on this matter. We are just trying to clean up the mess that we've dealt with. It's our obligation to do that, and we are doing it in quick order.
Thank you. We just need to let Mr. Dillon make a statement, and then we'll entertain questions from everyone.
Pleasant good afternoon to members of the media and those of the listening public. I wish to inform you that today Cabinet has approved the establishment of a child protection unit in the Trinidad and Tobago Police Service. It of course realized that within recent time there has been an increase in incidents of crime against children. In fact, our statistics between January 2010 and December 2014 highlights that there were about 1,575 males and approximately 2,407 females who were victims of crime. A further analysis of that data also revealed that there were 1,075 males were victims and roughly about 1,961 cases of sexual offenses against females. Of course, within recent times, we've also seen an increase in crimes against children. As against that background, the Commissioner of Police, with my concurrence, determined that we needed a dedicated and focused entity to treat the incidents of crime against children. And so this entity has been approved today. And it will comprise of 1 superintendent of police, 2 assistant superintendents, 10 inspectors, 18 sergeants, 28 corporals, 110 constables, and of course we're going to use about 36 special reserve police. Additionally, there will be 1 business operations assistant and 1 business operations, also 1 other business operations assistant. This entity will be spread across the 8 divisions in Trinidad and the 1 division in Tobago, throughout the entire 9 divisions throughout Trinidad and Tobago. We believe that treating with the incidents of crime against children should be one based on a concentrated effort. Notwithstanding, we understand that we know that murder is a barometer by which we are judged in most jurisdictions. There are other incidents that we must pay attention to, in particular, incidents against our children, where the children are the future of Trinidad and Tobago. And within recent times, we determined that there must be a concentrated and focused effort to treat with these incidents. But even in treating with that, the question of the kind of training that is required comes about. And so within this unit, the person will be selected specifically to treat the children. They will be trained appropriately, and the unit will be dedicated and focused throughout the 9 divisions to treat the incidents of crime and criminality against children. Yes. And of course, the qualifications let me just get a sense of the qualifications here, quite frankly. It really speaks to police officers who have a certain kind of temperament, police officers who have a sense of education, and also an affinity to treating with children, so that there's a sort of, not just a soft approach, but also an area in which they would be programmed to treat with children in particular and incidents against children. So that just in summing up really, this new unit is one of the other concentrated areas that in terms of going forward, one of the strategies really deals with concentration of a number of different issues within the criminal environment, within the crime and security environment. So while we treated the hard issues of murder and serious crimes, we tend that we must pay particular attention to our children and crime against children.
Thank you very much, Minister. And now we entertain your questions.
I'd just like to add before you move to that point, I did state a short while ago that this is an overlap between the Attorney General's Department and the Ministry of National Security. I just want to pull something close into the forum. Whilst we are about to debate in Parliament the amendments on Friday, the bill on Friday which deals with the Children and Family Court, I want to point out that we've taken great care not only to deal with legislation, another set of laws on the books, but what we are focusing upon is the operationalization of the legislation at the same time. That includes dealing with the resource base at the Children's Authority, dealing with the prisons aspects that are involved in relation to that, as they will now be dealt with by community, by homes, etc., under the new package of legislation, but importantly, adding in the dynamic of specialist training for police officers to have that assistance into the very system that we're now about to enable. The type of training for the police officers includes not only training in the specific area of law that they will be working under, but also psychometric testing as well. So that it's a very carefully constructed unit with very careful filters for the type of persons who will operate in that unit. And this is intended to meet the government's objective of not just passing laws on the books of Trinidad and Tobago, but ensuring that they are operationalized at the same time so that we don't have that long phenomenon of having a good law but just not being put into effect. Thank you.
Thank you, AG.
General, I just want to clarify, once the indicators are met with regard to the funding for the EU, for the ex-sugarcane farmers, when would those farmers then expect to be paid once the indicators are met?
Well, the position in relation to the indicators is quite unique because the written agreement prescribes indicators. The disbursement of funds by the EU requires achievement of indicators. But the position on the ground is in a state of disarray, where there have been disparate statements by the last government. At first, we won't pay. Secondly, we may pay. Thirdly, we may have paid. And so there's been a blur as to whether the legal requirement has now moved on and needs to now be clarified. So the obligation of the Attorney General's office, to answer your question, is simple. Bring the state of facts in alignment with the state of promises and the legitimate expectations. Clarify that position in law. Make sure you don't prejudice your funding in relation to this project or related projects from the EU. Then have the policy confirmed by the Cabinet of Trinidad and Tobago. This requires for 4 ministries to be coordinated: the Attorney General's Office, the Ministry of Agriculture, the Ministry of Finance, and the Ministry of Planning. When those 4 pieces are put together, and it's being done as we speak, then the position is clarified and we can deal with the lawful expectations that the country requires us to keep by, and which the Prime Minister has spoken to in very clear terms. So it is incumbent upon the government to get the story straight. That story which was spoken by those prior to us, and the current promise to make sure that the law is upheld and that we do right by promises and obligations which may be tantamount to legal obligations.
Who's expecting the payments from the EU funding and so on? What can you tell them in terms of their expectations given the situation as you have described it?
Well, we certainly intend to put this position clear, to put it public, and to have that consumed. I'd ask those who are affected by this to have a little bit of patience. We accept that the position may be that it's been long in the waiting when you look at it over the course of time, over successive governments. We accept that this is an obligation that must be dealt with quickly, but I'd ask people in Trinidad and Tobago to be very cautious about those who are now newfound friends and advocates to the cause, who sat down for 5 years and did precious little about it. I think that not only would a pinch of salt be worthwhile in this scenario, but a pound of salt may be worthwhile as well. Because the position is that it's got to be clarified so we do the right thing. That we do the right thing by the law and we bring it in line with expectations as well. So we just need that opportunity to confirm the position and then to deal with the process. But I really do wish for the focus to be upon the correct statements that have to be made. And I would ask those who are now newfound advocates for causes once forgotten, that they keep in line with what ought to be done. Proper progress and process is required in this.
Any other questions?
Increased the widened scope of the sanction surveillance of the SSA. What measures, if any, or what amendments to the legislation might also be brought to balance that, to prevent abuse, specifically, for instance, political abuse?
Very good question. Currently, you would be aware that the SSA, as comprised right now, deals with intelligence activities in law around drug activities, psychotropic substances, illegal drugs, etc. That was the convention that birthed the entity in 1995 or 1996. Added on to that in 2010 you will be aware, you'll remember, was the Interception of Communication Act, which put the performing obligation for surveillance into the SSA. Therefore, Trinidad and Tobago has before it a situation where intelligence has, since 1995, coming forward, been driven by the SSA. Where there is propriety and balance and protection away from abuse is the fact that this is intelligence-led and it must be handed over to the performing agencies, the Trinidad and Tobago Police Service, the customs, etc. So the performance of obligations that involve what is in the sphere of the TTPS is in the TTPS. The performance in customs is up to customs. But this is merely bringing home our obligations under several international treaties and other urgent matters into one unit so that it can be performed. We've been condemned as a country for failing to deal with weapons of mass destruction, which is an international obligation in Trinidad and Tobago. This, for the first time, attends to that. So it is to shore up the areas where we have shortcomings. Anti-terrorism is another significant obligation which the FATF and CFATF have condemned Trinidad and Tobago for not dealing with. Anti-money laundering, again another sincere obligation. We have been put into enhanced follow-up in the fourth round mutual evaluation process. And again, we are seeking to attend to not only national issues of importance, but our international obligations with due safeguard built into the system.
For instance, will the parliamentary reporting of the SSA be enhanced? Will agencies like the ACIB have custody of any intelligence gathered?
The ACIB is an entity which is seated in the Ministry of the Attorney General. It's a division of the TTPS in large part because of how it is comprised. The ACIB is still the ACIB. The FIU is still the FIU. The FIB, the Financial Investigation Bureau of the TTPS, is still that entity. What has been missing in Trinidad and Tobago, and is clear from our detection and conviction rates, standing at one point most recently at 3% for homicide, which included murder and suicide detection as well. What has been missing is the efficacy. People believe that there is no consequence to crimes, and therefore it is incumbent upon a government to enable a structure to allow for a significant improvement of detection and conviction rates. And that requires a government to bring an holistic approach towards de-siloing and putting information so that the left hand knows what the right hand is doing in a coordinated and efficient fashion.
Might the role of the judiciary be widened to increase their oversight of surveillance? The judiciary, for instance, have a role to play in the interception of communication.
All of the laws stand as they do. If there is to be an interception of communication, it must comply with the Interception of Communication Act. You must have a warrant in certain circumstances to do that, etc. None of that is affected. All that this does is to allow for the broadening of supervision so that you're not only confined to drug-related activities, because what is attached to drugs? Trafficking in persons. What is attached to that? Firearms and ammunition. What is attached to that? Money laundering. One has to accept the realities that the drug empires are associated to all of the scourges which plague our society. Therefore, it is axiomatic and logical that one takes an holistic approach to centralizing this information, lest we be left in the terrible situation where crime continues to be a scourge upon us all without any form of reprieve. It is time for the government to be seen to be acting sensibly, and as we've demonstrated with the children's legislation, not only passing laws, but operationalizing them.
Previous reports of the Auditor General have raised questions about spending at the SSA. Given its increased mandate now, under these proposals, what steps will be put in place to enhance control in relation to that specifically?
You will recall that the Prime Minister has stated publicly, and the policy of this government adopted as policy includes current accounting mechanisms. The Minister of Finance is busy in his approaches, and so too is the Auditor General's department through the Attorney General's offices in improving the efficiency of those agencies. I have met with the Auditor General, and I'm receiving from that department legislative amendments that they require to strengthen their supervision of activities so that they can not only be current, but that they can be efficient. We are bringing legislation very shortly to deal with some of these issues. They will be pronounced in our legislative agenda, which, as I have promised since day one, will be published before the first quarter of this year, if not sooner. And we certainly intend to bring better efficiency to the matrix.
Will the proposed review, you mentioned, Minister, that it will involve looking at the criteria of eligibility and reducing operating expenses. Is it possible that one outcome might be a reduction in the number of students covered by GATE?
Yes, but I'm waiting on the report of the task force. I don't want to prejudge the work the task force will be required to do. But there might be many outcomes, and let us wait and see what report the task force will come up with.
Yes, finally, in relation to the cane farmers issue, Attorney General Al-Wari, you mentioned that one matter that has to be considered with legitimate expectation. With some payments previously having been made, do you think that cane farmers did have a legitimate expectation that payments would continue, and what would be your response in terms of proposed court action? Will you fight this in court, or will you make payments? And finally, the issue of the Dangerous Dogs Act was recently raised with a tragic incident a few days ago. Should Rottweilers be included as a dangerous dog?
In relation to the legitimate expectation issue of cane farmers, there are two perspectives to be balanced as a government. The first thing is in making sure that you comply with your obligations as are recorded in agreements and in respect of which you're bound by the law. The second hand, which is equally important, is to make sure that the persons who have been brought into the position of having a legitimate expectation have their legitimate expectation satisfied, because that's also an equal legal obligation. What is required right now is to harmonize the approaches by making sure that everything is clear. A pre-action protocol letter was written by no less a person than Gerald Ramdeen, someone who has easy access to all of the information that we've just put out, the Minister of Finance and I. Nowhere in his correspondence dated the 9th of March 2016 is any of what we've just said reflected. He has engaged in what is referred to as the pre-action protocol process. That process requires that there is a response with a view to avoiding litigation if possible. And obviously, any serious government intended to be bound by the Chief Justice's prescriptions to avoid litigation where possible would be taking avail of that, as we will. We intend to respond as is required in the pre-action protocol process to indicate the positions which we have just articulated so that the parties can come together and map the way forward, because the best help is self-help. But it is certainly not going to be facilitated by irresponsible newfound advocates who are really riding the backs of those who are most in distress. Relative to the dangerous dogs issue, we spoke, I'd remind that the legislation to deal with dogs and the control of dogs was dealt with by a dog control bill, and there was an amendment to the dog control bill that was in 2013 and 2014. The law was assented to, and then it was proclaimed in 2 stages. The current position in the law is that Rottweilers are not included in a class referred to as Class A dogs. Rottweilers and any other dog that demonstrates dangerous behavior has the ability under the legislation to be reported and therefore treated as a dangerous dog. This very tragic incident, for which we all as a government express heartfelt condolence to the family that has had to bear this and the community that has had to bear this. This incident happened by virtue of a family pet, not a dog who was unknown to the family, etc. But there is also a liability that people in society bear and a responsibility to make sure that they know the risks and dangers that they themselves may be exposed to or have. No one government can put into effect all of these things, because having a Class A dog that is owned by a family where the dog itself engages in this kind of activity is the same as a Class B dog. It's the family dog. So is it that the owner is going to sue himself Is it that the owner is going to draw upon his own insurance? There would have been an exculpation from insurance by the owner of a Class A dog or a Class B dog because it's the family dog. That's where the self-monitoring has to come in and where the double tragedy is in this experience. So from a government perspective, certainly it requires to make sure that the law is properly enabled, that the regional corporations are able to manage the reports that come into them, that speak to Class B dogs, which should be considered as Class A dogs, that there's monitoring for the supervision of Class A dogs. The last government did not report to us about the position of insurance in relation to Class A dogs. It's something we're looking at right now. But it's equally incumbent upon people in society to recognize the dangers which we may have in our own homes, be they fire risk, be they a dog that is a family dog that goes wrong, be they the Zika contamination that the Aedes aegypti can solve. We have to help ourselves as well in this dynamic.
Okay, Davis for 102.1 FM. Good afternoon. To the Minister of National Security, you spoke to the establishment of a child protection unit. I am trying to establish whether there shouldn't be equal or more intense emphasis on adult or parental education so that the work of the child protection unit will not be as demanding as it should be if you have other forms, this other angle in support. Minister of Education, could you give us an idea of the numbers of students currently under the GATE program for the period September 2015 to the present? And to Attorney General Faris Alwari, you spoke about the management of youth offenders. Earlier on, I am asking, where does the family court, and on the other hand, something like a mediation court, fit in the context of this management of youth offenders? And last, but certainly least, I think, you spoke to a second tranche for the Exeter Colony cane farmers. What would have been the quantum for the first tranche, and would the indicators be seen?
If I may comment, first of all, and with respect to the Child Protection Unit, it's not to be treated in isolation, but in looking at what we consider the whole of government approach, we realize that there is, in fact, collaboration and cooperation between the Ministry of National Security and the Ministry of Education. And so far as not only the parents, but we're looking at the school system, the teachers, the PTA, and so on. All of those bodies are involved in dealing with the entirety in terms of, because you can't treat the children alone. You have to look at the responsibility of the parents, the responsibility of the teachers. I'm even going so far as to say we have to look at the responsibility of the communities. And so that is why in putting the Child Protection Unit in the various divisions is based on, again, an interaction with the policemen so designed within the communities.
Thank you very, very much for your question, Ray. Since the inception of GATE in 2004, there have been 194,000 students who have accessed GATE, and that goes from September 2004 to September 2015, over that 11-year period. Okay? And as I indicated earlier, 65 institutions are allowed to facilitate this whole GATE program.
Would you remind me your first question? I have recorded your second. Sure. Okay, the management of the youth offender system is a very core and fundamental aspect of the legislation to be debated on Friday. The current move is to move away from the YTC labeling. Currently, YTC has charge cases, or I should say previously, the YTC had charge cases and convicted cases. Children who were on remand, including children who were deemed, or in respect to which applications were made to deem them to be out of control or beyond control. So there was a mixing of people who had been already convicted and people who were not yet convicted or who could be released. That position is being sought to be cleaned up so that we no longer talk about juveniles. We talk about children charge cases, children conviction cases, that there is a separation of the two entities, and that there is care and caution in how we treat with these children. YTC had children, quote unquote, up to the age of 24 and beyond still in YTC. So it was a very messy situation. The position of management of youth offenders and alternative dispute resolution is being birthed in a very interesting and novel way, not only by alternative dispute resolution being a range of remedies available to a court, because there's a wide discretion in the court to apply certain remedies. This is the proposed division of the court. But also by way of something called peer resolution, which is children who are specially trained and involved and supervised in a process where peers review children in difficulty, because sometimes it's more palatable and more productive to have that form of approach to children. So it is a significant improvement upon the management of the children's situation. It complements with the operationalization efforts that the Ministry of National Security is driving, as can be seen by the creation of the unit that we spoke about in the TTPS. And really all of this is intended to not only have good laws on the books, but to make sure they're operationalized properly. You will recall that upon entering into office in September, I inherited my first matter called upon to deal with while I was being sworn in as Attorney General on the same day at the same time, was a situation where the previous Attorney General had proclaimed law, which he then, as an attorney at law, sought to deem caused an unconstitutional situation. It's quite an unusual circumstance which went to the court. And that is something which we don't want to make an obscenity of. We need to make sure we operationalize properly whilst we pass laws. Are there any other questions?
The question that I asked relative to the first tranche that we
Oh, thank you. Your second question. The point is that what we need to do is to get the material. So the verification and vouching exercise is afoot relative to payments and how they were made, etc. The Minister of Finance, as he spoke to, is in the course of confirming the exact particulars. And once we have the particulars, we'll be able to speak with certainty. We don't want to make statements like monies were received when in fact they weren't, as you found out a short while ago. So we've got to get the facts straight, and that information resides in the 4 ministries that I called earlier: Planning, Finance, Attorney General, and the Ministry of Agriculture. And we've got to bring all of these pieces in together first.
Hi, good afternoon, Peter Christopher from CNews. My question is to the Minister of National Security. Yesterday you met with the leaders of the executive services, and the union leaders were not totally impressed with what came out of the meeting. Would you like to divulge what may have been discussed during that meeting, and if there are any decisions in terms of how you're going to protect officers in hotspots?
In that meeting yesterday, we touched on several areas, and the meeting was really called to update the associations on a number of issues, some of which include the arrears of salary, the payment of arrears of salary, and they made a commitment that the arrears of salary would be paid sometime in July of this year. It was also updated in terms of compensation. We discussed compensation issues to the next of kin of relatives of person who died from the services. Issues to that area was also discussed. We looked at the absorption of the auxiliaries into the fire services. We looked at the absorption of the SRPs into the Trinidad and Tobago Police Service. And of course, most important, the agenda were the issues of safety and security, not only the prison officers, but all entities within the national security environment. Because first and foremost, we cherish the lives of the people who served us in the Ministry of National Security. And almost all of the agencies, they're almost there to put the ultimate sacrifice. They put their lives on the line, whether it is the prison services, whether it's the police services, whether it's the defense force, whether it's the fire services. And we have situations where they have been killed in the line of duty. So one of the issues, of course, that we discussed was how do we go about in terms of protecting these agents of the state when they execute their duty. And we've come up with several strategies, which in terms of that, there are 2 issues that was prominent in the discussion. One had to do with the issue of housing, moving people from high-risk areas, and of course offering some degree of protection in terms of arming some of the persons as concerned. Let me deal with the arming first. In terms of arming personnel, it cannot be done in a sort of a carte blanche atmosphere. It must be done based on a needs, based on a threat analysis, and based on issues pertinent to individual basis, and that's the way going forward. So that it can be done and that you're issuing arms to every single individual. If we do so, then we create another kind of problems. So the discussion would be going forward is how do we place those kind of criteria in terms of providing the necessary kind of arms for personnel. The other issue has to do with housing, and that is removing people from high-risk areas. Now, that again has to be done, is a very complex issue. It has to be done again based on an assessment of the individual, where they live, what are the threats based on them, and therefore how do we take the necessary action to remove them from that environment. Because one cannot use as a yardstick the reason that you are living in an area that we remove you from that component. One of the balancing endeavors has been to put security personnel in various communities with a hope to strengthen those communities, so that in communities we said we have policemen, we have soldiers, we have prison officers, we have fire services officers, and so on. And it's believed that with them in those communities, they would strengthen the communities by their mere presence. Now, if for some instance, for some reason, there's a threat on somebody's life, then we take that very seriously. And we put measures in place to offer some degree of protection. So there are two areas, and we're looking at strategies as we go forward to treat it in a long-term manner.
Ladies and gentlemen, I just want to put onto the record that we have had now 6 months in term. Specifically, the Prime Minister indicated very, very early that we would go under a review process. That target was met. Our 6-month anniversary met us just at the end of our retreat in Tobago. The review included an analysis of what the state of play in Trinidad and Tobago was, be it in the protective services, be it in the respective ministries. The fact is, it is only when one has an appreciation that there are 3,000 homes in the HDC available and there are 300,000 applicants that you get a sense of scale. Therefore, meeting all of the requirements of all of the protective services by that mere anecdotal figure is a near impossibility. So the prioritization of protective services right alongside the needy, right alongside the aged, etc., people who have been waiting since 1971 on the list of the HDC, NHA as it was, all of these things have to be put into the mix. It was specifically also stated by the Prime Minister that that review that we underwent into the cabinet, etc., was something that was going to be dealt with by ministries, bringing forward the agendas that they have worked on relative to the prison service and other protective services, the TTDF, etc. We will, in the Ministry of the Attorney General, be rolling out public consultations on the facts that we have found and the proposed solutions, and asking for views not only from the various respective entities that represent, be it prisons, police, etc., but also members of the public. So this review of portfolio, each minister's management, etc., that we have all engaged in, is something that we had to engage in so that we could speak with clarity as to what the position is. We will all be launching very publicly, each minister, our respective approaches to the issues under our respective management. And that is going to be a significant point of delivery for Trinidad and Tobago that I'd invite you to pay attention to and to participate in. It ended after the retreat, the process of analysis and positioning, and it is being unraveled and unfolded for delivery as we speak. The Attorney General's office will be doing it this month. On several items, I announced it in Parliament. I was a little disappointed that nobody picked it up, but that's what second chances are for.
The Attorney General, the expanded powers for the SSA, that legislation, would that have to be accompanied by any amendment of the Interception of Communications Act?
No.
And just in terms of the, as Andre had asked earlier, in terms of the housing of this information and whatnot and the parameters of it, would that be more specifics than what is already contained in the Interception of Communications Act?
No. The Interception of Communications Act is a standalone process by which you intervene, and that is recorded and vouched and under judicial process, etc. That has a sufficient balance and purpose for it. The intelligence-driven nature of this expanded remit is perhaps not different from what it's doing in some senses, insofar as a lot of activities, gang-related activities, firearm activities, money laundering, trafficking in persons, trafficking in children, which is a specific aspect of it, are all touching the same cornerstone of drugs.
For the Education Minister, I'm being told that there's been some issue with short-term contract employees in the education ministry in terms of salaries. Is there anything you could shed light on that particular matter?
Well, we have a number of contract positions, and in some of the positions, the majority of persons' contract came to an end. And what we are doing now is reviewing that in an effort to have those positions filled.
In terms of payment of salaries, I'm being told that there may be some issues with payment of salaries with short-term.
For my information, all persons who are in the employ of the Ministry of Education have been paid their salaries.
Okay, thank you. I'll try.
Can I just ask, the Attorney General, this one is short and sweet, would the amendment to the SSA bill require special majority, yes or no?
No, it doesn't.
And to the Minister of National Security, and perhaps the Attorney General as well, the recent report of the Children's Authority said that there were, I think it was about 4,000 instances of child abuse over the last year. And the report said that in 300 cases, children were actually moved from the home. That seems to me to be a very small number, given the figure for abuse. And there is a problem with placement of children who are at risk. There are no places in there aren't really institutions for them, because most of the institutions are like St. Jude's and so on, for children who are in fact have behavioral issues and not just, not for abused children. So how, in the face of all of that, this police protection unit, what is going to happen down at the other end where children are identified and need to be moved?
I can just answer that very quickly. I'm very pleased to say that part of the operationalization that the government has engaged in includes the delivery of halfway homes, community centers, and specialist projects to deal with exactly the housing issue and treatment issue that you have just addressed. That is something that is being driven directly from the Office of the Prime Minister under Ayanna Webster Roy, the Honorable, and also Community Development in conjunction with the Attorney General and Ministry of National Security. So that is something which we will speak about in great detail in the Parliament, and we're very pleased to say that we have looked to the operationalization issues at the same time as the legislation and position creation.
$194,000. In excess of 20, if you want those, in excess of 20,000 students. Yes. Okay.